may I be permitted to mention for inclusion in the list restoration application?
Your Lordship, may I be permitted to mention a matter? This is an execution matter, Your Lordship. This was heard on 21st of May, whereby Your Lordship had directed the award debtors to pay a sum of rupees 23 lakhs by installments within a period of 6 weeks. Your Lordship, we haven't received any sum yet. Your Lordship had granted liberty to mention the matter in case of any default, Your Lordship. Kindly keep it next week, Thursday, Your Lordship.
My Lord, mentioning again, yesterday I've mentioned, we have served upon the official email ID of the respondent, item number 101 and item number 102 of the monthly list, my Lord. These are the matters ready for hearing. Affidavits are complete, my Lord. Several occasions, my Lord. Section 9 application, my Lord. I have a 300 crore award, my Lord. I have post award section, and any day I will again issue a notice, my Lord. Even in August, any day, my Lord. Your Lordship's convenient, my Lord. Kindly, my Lord, fix a date and a time, my Lord. Kindly. August, mid-August, any time, my Lord. Whenever it is convenient.
We'll see. Give your
It's there in the monthly list, my Lord. Oblige.
But I am applying for the petition.
So this will come as petitioner.
Yes.
Respondent.
Grateful.
Grateful.
Number 2.
My Lord, in item number 2, my Lord, I am for the award debtor, my Lord. I have filed an application under section 47. However, my Lord, under compelling circumstances, my Lord, I am for an accommodation day because the conducting advocate and my wife, Miss Progga Bhomik, my Lord, she was to be hospitalized yesterday night, and I was entirely stuck there. So, my Lord, I couldn't come to court today. I need to, my Lord, rely on several judgments. Earlier, your Lordship has opined that the matter should be settled. We have attempted for that settlement, but the petitioner has said that they are not inclined to settle it. Now, the entire assets and the address of the company is beyond the original jurisdiction of this court. And the award was also passed, my Lord, by MSMED in this has not covered. So, my Lord, today I am praying for time. So next week I will do this matter, my Lord.
You are appearing on behalf
I am for the award debtor, my Lord. Award debtor.
learned for the award holder.
Award holder.
Mr. Arnab Chakravarti states that his wife has been hospitalized and seeks an adjournment on personal grounds. Let this matter be adjourned for a period of how much time?
Not 1 week. I will do it in the next week itself.
2 weeks. Stop.
Next week, huh? Get killed.
Deeply obliged.
I am for the award holder, my Lord. Pursuant to a last direction, there was a direction upon the judgment that award debtors to file their affidavit of assets, my Lord. We have served, they have refused. The affidavit of service, my Lord. I was praying for a warrant of arrest be issued, my Lord. A petition down একটা কেউ petition.
Despite service. How many are there?
My Lord, one.
Only one.
Only one award debtor. Huh? 2 addresses are there. We have served upon both the addresses. Both the addresses they have refused.
Despite service, none appears on behalf of the award debtor. This court, by order dated 18 June 2020, had directed the award debtor to file his affidavit of asset. The same has not been complied with. That warrant of arrest be issued against the award debtor. Number 1.
On only one.
Award debtor.
One award debtor.
Requisites
One
to be
award debtor.
deposited. Concerned police station shall ensure that the warrant of arrest is duly complied with. Deputy Sheriff to file the warrant.
পুলিশ স্টেশনে বেল করিয়ে হবে মোস্ট প্রবাবলি।
And for the award holder, my lord, this is the order, my lord, passed by the MSME Council. My lord, this is an award of, my lord, around 18,70,060 rupees, 20 paise. My lord, we have no idea of their bank accounts or their PAN number. Only pre, my lord, they don't, for injunction, my lord, they don't remove any of the assets, or dispose with any of the assets.
Where's the award?
The award is at, my lord, it's at the end, my lord, with the application. The award of 13th of January 2025. When it comes to
The
the,
problem is these awards have to be signed. It's not
this is a
ex-
certificate copy, my lord, they are handing over.
you have to write to them, get these awards signed by the arbitrators. You know, there's a requirement.
That's
under
the difficult. I mean, we have already, you know, twice or thrice, but this has been pointed out by different courts. This has been
what to do. I mean, we can't execute an award which is honest in the eyes of law.
this
The
is that
difficulty has to be, you have to overcome the difficulty.
when necessary direction will be given upon them. My lord, then we say, my lord, they didn't do anything. This is a certified copy they're issuing in this manner.
Write to them. I'll keep it after 2 weeks. This can't be, this is not executable.
There may be one line order, at least we can write to them. This order is being your unsigned order.
Learned counsel for the petition has preferred the present execution petition seeking execution of the award dated
The award is 13th of January 2025.
15th of January 2025.
It passed by the Chairman WB MSME Facilitation Council.
This court notes that the award is not duly signed by the arbitrators and the certified true copy of the award only bears the signature of the Deputy Director, SSE, Directorate of MSME, Government of West Bengal. Full stop. The petitioner is directed to procure a signed copy of the award for the present execution petition to be maintained just after 4 weeks.
Didi. Why? Please, your lordship.
Yes. Yes.
This is my execution application, my lord,
Yes.
for recording really, my lord, satisfaction of the decree, because, my lord, in the arbitral award, my lord, it was a claim for specific performance. It would come back to your lordship, my lord, it was a claim for specific performance where the consideration was enhanced. Now, my lord, they were given a time to, my lord,
Same matter where
yes. So they were given a time to make payment of the enhanced consideration,
Yes.
and it was the consequential obligation on my part to, my lord, execute the conveyance. There's a default clause provided that, my lord, in the event they do not, my lord, then, my lord, I'll have to refund the earnest whatever money we have received.
Yes.
They have not. We have offered the refund. We have tendered that. They have refused. They have filed a Section 34 application that is pending. Now, my lord, there is a no stay, and I have been instructed, subject to correction by my learned senior friend, my lord, that they have not even paid for a stay.
My lord, with respect, my lord, there's no averment in the application how this honorable court has jurisdiction. The award is sought to be executed against person and property. Person now, no property. Person outside jurisdiction. It has to be filed in the court where the person resides.
where's the property?
Property is in Jaipur. I am also in Jaipur. 39 is a complete bar. 39-4, your lordship kindly sees, and one decision of the Supreme Court that once the award is a deemed decree, 36 kicks in. Execution has to be in terms of the Civil Procedure Code. 32 has no manner of application, seat, venue, all that becomes redundant. And the award can be filed wherever the person is, or the property is, or the money decree is.
Yes, sir.
Otherwise, I would have bowed down to what my learned senior friend is submitting, but kindly sees my prayer in the tabular state.
Whatever be the prayer, it's a lack of
Kindly-
subject matter jurisdiction.
Kindly-
Even in the prayer, we are not concerned. How is
Your lordship would kindly have a look at the
credibility
prayers
is an
once.
issue?
Really, my lord, I am not claiming execution in respect of any property outside. If your lordship kindly sees the tabular statement once, had that been so, I completely.
Even the respondent is outside jurisdiction. Nothing is within
The
jurisdiction.
arbitration has happened here.
Yes.
Now, if your lordship kindly sees the tabular statement, my lord, your lordship would find that all I seek today is, my lord, the recording in terms of Order 21, Rule 1 of the money which has fallen due and payable under the award. I am not wanting anything, any attachment, any order in respect of any movable or immovable property.
That's right.
So, I'm sorry, my lord,
But the award debtor
is outside.
Is outside.
Award debtor is outside. Now, my lord, in this case, my lord, the arbitration was held within.
That's all right.
So, my lord, all the judgments your lordship would find, and my lord, I also tried to, my lord, do some research on that, is where the person and property is situated outside. I should go there. That is when I am seeking any order in respect of it. But otherwise, my lord, if the seat is here,
There is an order. There is a direction which you are seeking against.
there is a direction which I am seeking, but that, my lord, does not, my lord,
Against a person who is not within the territorial jurisdiction of this court. So in that case, then you should file it in Jaipur.
39.4 is
Person
a
is
complete
residing
part.
there, then it should be maintainable in Jaipur.
but I am
Unless
really
and until you
not
have-
seeking any order against him.
That's
Your
right.
lordship would find that I am not even seeking any order, no direction I am seeking. I am not seeking any attachment of any bank account or any property. All I seek today is recording of the satisfaction of the award passed in within. So, well, had I sought
if you
for any
in-
order,
If you insist, Mr. Gupta, all I can do is he'll file his reply. I'll hear you.
I file my reply on the point of maintainability.
The point of maintenance, then I have to allow him to file his reply. Maintainability, if that is
we
the
can have
issue,
this heard out, my lord.
I need
We
to
can
prove
have this heard
Yes.
because there is no factual dispute between the parties per se.
if he's
On
raising
this
the
issue.
point of maintainability,
to be on oath.
then I have to give him an opportunity to file his reply.
Could I,
39.4 is a
I-
complete bar.
would your lordship kindly pass it over? My lord, could I just have a
I'll pass it over. I can keep
Yes.
it next week also. You can come back. Whatever is up to you.
as your lordship?
Take instruction.
As your lordship, please.
No, whatever is convenient for you.
But I
Pass over the next day.
Come
next
back
week, my lord, but
Come
only
back.
thing, my lord, next Thursday I'm not. Thursday and Friday I'm not there. Could it be on Tuesday, my lord, or Wednesday, my lord? Whenever.
I have my execution days on Thursday. Join online. You're not,
I'll be traveling, my lord.
she'll come in. It's just for instruction. We won't pass any orders. She
Very
can come and.
Great.
Next Thursday.
But happy for the petition award holder. But they have taken the issue of
Important.
limitation. But it appears not in the affidavit in support of the tabular statement does not disclose all the papers. But we have prepared an application. It's being filed. It's being scrutinized there in the department. So Lordship kindly takes up next Thursday. I think
Not
this can be done.
We are taking the point of the education application is barred by limitation. It is
Not
filed.
today. Let us.
That's the reason I've said so. I'm trying to explain it. But what I'm hopefully telling him, previously also there was an execution application filed. There's some kind of order mentioned, but nothing has been said about that. So I want to incorporate that application. So I'll serve you a copy also. Later.
Time for the respondent.
At 7, I'm being led virtually by Mr. Garg appearing from
Mr.
Mr. Garg. Item 7 will
She was there. She logged out just now. She was there. I saw because we have appeared in the arbitration as well together. Your Lordship, in this point, there was already a direction by Your Lordship on 18th of June for filing of affidavit of asset.
Yes.
we are taking the point of jurisdiction because our office is based in, we are Southeastern Railway, our office is based in Garden Reach, which Commercial Court Alipur will have the jurisdiction. We have already filed a section 34 and 36(2) over there, which has been fixed on 3rd of September 2026. Your Lordship, this is a marked copy. I apologize, Your Lordship.
You're not there. Yes, madam.
Please, my lords. I'm so sorry, my lords. I was sitting in another court. My lords, this is an execution petition, my lords, where they, although my learned friend is admittedly filed the section 34, there is no stay. And therefore, my lords had on the previous date asked for a disclosure of assets on affidavit.
Yes, filed a 34 and 36 both.
My lords, that would be mine.
And before the commercial court at Alipur.
Yes, my lords.
So for her, she's saying that this execution petition is not maintainable before this court. Because
If my lords,
the jurisdiction would be the commercial courts at Alipur.
well, as I understand it, my learned friend may file a reply, I can file my rejoinder, my lords can decide on the issue of jurisdiction. We are certain that the jurisdiction is of this honorable court.
Madam, if their office is situated in Garden Reach, which is beyond the territorial jurisdiction of this court,
811 para 34
then
of their
it is
petition, they
admitted.
have only stated
Then where's
about
the question
pecuniary
of filing
jurisdiction.
reply and all those stuff?
Would my lords grant me a short opportunity to just examine this?
If you seek instruction and come back and file it in the appropriate.
Yes, my lords.
Would my lords take the affidavit on service on record?
Oh, come back on Thursday.
Gratefully.
Well, in item number 8, my lord, I am for the award holder. This is my execution application, and I have filed a GA, my lord, connected to that execution application for transferring of the award, my lord, within the jurisdiction where the properties of the judgment debtor are
Why
situated.
don't you just withdraw and file it there?
My lord, I am about on, my lord. The problem is, my lord, this is an award arising out of a settlement that arrived at in a 12A proceeding of Commercial Court Act. My lord knows, my lord, that under section 12A subsection 5, the settlement is an award under section 30, my lord. Now, my lord, although this is an award, the proceeding is not a arbitral proceeding. There are judgments, my lord, of Supreme Court, my lord, with in Sundaram Finance Limited, my lord. I'm aware of all the position, my lord, but the difficulty is, my lord, I have already filed an execution application in Bangalore, where the properties are situated. However, there the judgment debtor has filed a section 47 saying that this court has, the Bangalore court has no jurisdiction because it is arising out of an settlement. My lord, on this ground, my lord, I am only seeking, let this execution application be transferred, or in the event my lord holds and observes that there is no requirement of transferring this award to any other court.
If you have already filed execution proceedings
My lord,
for the courts at Bangalore,
yes,
how's this maintainable?
because the mediation process held at the mediation committee of Honorable High Court at
So, but
Calcutta.
if you have already, you are saying that you have already filed execution
My lord,
proceedings.
my lord, I can file, my lord.
You are seeking transfer of these proceedings to Bangalore.
Yes, and that event, in that event, my lord.
Madam, if you have already filed it, then why are you seeking transfer of these proceedings?
My lord, I am
You should
going to
just withdraw it,
withdraw.
yeah.
I am going to withdraw the Bangalore execution, my lord, in course of time, because there is a property
How
that.
that's maintainable if you have
My lord,
filed
I
it?
can file, my lord, several execution application, my lord, since
No,
this
you're
court
asking for
has.
the you can file several execution application. If the properties are located at different locations, you can file your execution. But you are seeking a transfer of this execution petition where you have already filed in Bangalore for the same cause of action.
My lord, I understand, my lord. Only thing,
You're
the
not
Bangalore
seeking
court,
different places.
Bangalore, as per the, my lord, judgment data, since they have filed an application,
So
my lord.
how is this maintainable today when you have already filed? You are seeking the same relief. You have already gone to the courts in Bangalore.
My lord,
Today, you want in this application, this petition should be transferred to Bangalore, where you have already knocked the doors. You have already filed the petition.
My lord, in that event, may I come back?
Court will file.
I mean, I understand. I have to. My lord, there is. I mean, there are lawyers that sitting in Bangalore, and I can understand. Man, I'll speak to them, and I'll convey the observation
This
from
is not
this court.
maintainable today.
My lord,
This is forum shopping.
My lord, I'm praying for an adjournment. In that case, my lord, I'll come back on the next week. Kindly grant me some liberty.
If you had not filed it, I can still understand this application is
Well,
maintainable.
I bow down, my lord.
Now this application is not maintainable, madam. Not maintainable.
My lord, I'll come back, my lord, on the next week.
Not today.
No, 9.
My affidavit of service, my lord. This is an execution application, my lord.
Yes.
My lord, of an award of 23rd of July 2024, my lord. But as far as I understand, my lord, my learned friends have also filed a section 36(2), my lord. But my lord, this has been there for several years, my lord.
You have deposited the money?
No, my lord. Let them deposit the money, my lord. I made a calculation. I've already handed over, my lord, a chart.
May I, subject to my lord, the award has been challenged by both the parties. Section 34 is pending before your lordship. We took out an application under section 36 also. Now, lordship, that is also pending before your lord, my lord. Now, my lord, what I am humbly submitting is, my lord, let the section 34 be heard out, my lord, because then, my lord, the matter can be. Otherwise, my lord,
but at least deposit the money in 36.
Then my lord will kindly allow my 36 to be placed before your lordship. It is pending in my lord's list, so that my lord, necessary orders may be passed.
Award is of which year?
2024, my lord.
My lord,
As on date, my lord, 8 crores,
within time.
46 lakhs, my
Filed
lord.
it within time.
But I also, my lord, I am a company, my lord. I'm now dwindling down, my lord. So that's why I made the execution, my lord.
The pleadings are complete as far as 34 is concerned, lordship. What I humbly.
Their application is item number 204 in the monthly list. That's what I know, my lord.
Meantime, I'll give them a direction to file the affidavit of asset.
Yes, my lord. Well, kindly does that.
Not required. Indian Army is not required. No, lordship,
Indian Army.
Lordship, what I'm humbly submitting.
Then I'll list the 36.
Lordship, what
I'll list the 36. I'll list the 36.
Along with this, my lord, then that would be
along
better.
with this. Along with this. So I'll next week. Give the number for 36. Give the number. Give the number.
No, only 36 and the execution.
Lordship is pleased to keep it.
When do you want, Mr. Trivedi?
बहुत दूर हो जाएगा.
Advantage ले रहे हो.
Lordship, whatever falls from my lords, but it will be very convenient if it is on 18th of August. Lordship will not taking a risk, because my lord, what has happened with me, the biggest problem is, my lord, that new matters I am not taking, but whichever matters were there when I was not an incumbent in office, my lord, all those matters are fixed for hearing this time, my lord.
This to Ms. Pandey can also.
No, my lord, then
But
whatever falls.
this is just a 36(2), my lord. I don't know why
My
they
lord,
have asked for
whichever date for is.
Not for arguments at all.
My lord.
This is 36(2). You have to.
My lord will kindly, if my lord's diary permits, 6th of August, lordship. If my lord's diary.
This of August.
I'm grateful.
Top of the list.
Because this is only to.
My lord.
6th of August.
Let it retain its whatever.
My lord.
Both execution and the 36. Take the number.
I'm grateful.
I'm giving it. But I already handed a calculation, so he would be knowing. Very grateful. Huh? No.
Order record. Should I record an order or Mr. Trivedi?
My lord, as my lord deems fit and proper.
No, but
no, my lord, I don't mind whether recorded, not recorded.
ASG needs.
My lord, my juniors, my lord, but
the juniors need one, I think. Well, if you'll also kindly record something.
Learned Counsel for the respondent. Auditor states that application under Section 36 of the Arbitration Conciliation Act has been filed. Let this execution petition and if whatever the number is be listed together on next Thursday.
He's saying that who will eat on his behalf. I said, I am there.
I am a person, my lord, who has no one.
Lot of people.
Grateful, my lord.
See, he's always
single man. Whatever I have, From my ancestors, that is more than enough for me.
Mr. Ray is always there to help you.
Yes.
Just
I
about
am
mentioning,
grateful.
my lord, I have too much of liability, my lord.
My lord,
Take care of it, don't worry.
He is my college senior, so he should.
grateful, my lord.
I have a liability this time.
My execution application, Lordship. Lordship, in this matter, Lordship, few orders because I can understand opposition coming. So I, few.
Mr. Banerjee is there, opposition is there.
Yes, that's why I indicate, Lordship, a tender of 2010.
Lordship, he will make an submission.
Let me.
I will not make any submission. I will make only one submission.
Yes, I know what
I
is
will
that.
pray for 3 weeks' time.
Yes, I know.
Let him make his submission.
Let him make his submission now.
Lordship, tender of 2010.
Tender of 2010.
Work completed. The only claim that was Lordship will kindly come to the section 30 page number running page number. Lordship will kindly come to page number of the execution application. GA1
34 over 37 over.
No, I'll get only one claim, work done not paid. I'll only work done not paid. That is the only claim, and that has been awarded. And a small minuscule amount of 8 lakhs for compensation has been awarded. That's all that has been awarded in 2019. Or a work of 2010. 2019 award passed. 2022 section 34 dismissed. 2022 appeal filed. Appeal dismissed for default in 2025. May 2025 appeal dismissed for default. June 2025 they file a restoration application. And every month they mention, according to their version, and it does not come up. After 1 year of this going on, Lordship had passed an order of attachment, saying to Mr. Sinha that on the next occasion, although not recorded, but that matter where calculation mistake on my part, saying on the next occasion, if nothing comes from the appeal court, amount will be released. This was the position till that time. So 2010 work for work done not paid to me, and 2026, I am still running out of pocket. It's not a case of damages, compensation granted to the tune of crores, nothing like that. Lordship I am only beseeching Lordship the position. A new set of advocates, they will seek time, they will say a lot of things with regard to adjournments. Only see this position, what is happening. I have shown those judgments, I am not placing those judgments again. Division bench judgment saying that if there is no stay, even if 34 is pending, 37 is pending, 36 too is pending, division bench says that immediately amount has to be released. I had placed those division bench judgments before your Lordship. I'll again, if you're...
Yes.
Lordship, of course, what my learned friend said is correct. But Lordship, I cannot say anything about what happened previously. Today we mentioned it. Upon notice we mentioned it. My learned friend was present there. So far as 2nd April 2026 order is concerned, Lordship has already attached my bank account. So he is secure to that. So far as courtroom number 37 is concerned, I know that on the date of restoration, usually court takes up the matter and dismiss or allow it on that day, means hear it on merit. So Lordship, we have mentioned, and that court, no effort usually to be taken by the parties to list it. Usually it gets listed.
Yes.
So Lordship mentioning has been allowed. So if your Lordship kindly keep it after 3 weeks, I think we can come up before your Lordship.
So attachment has already been done. What do you want? Release?
2nd
Release
April
of-
2026.
37 is pending.
Yes, this has been done by the division bench also, Lordship.
Sure, it has been done. I am not doing.
Lordship will kindly take this judgment once.
Very good.
This has been done when 36 too is pending also.
All right. Very good.
I'll place those judgment, Lordship will kindly, because
Good, sir. Very good.
there has to be some end to the litigation. Otherwise, this is going on and on.
Both of you mentioned it before the learned counsel for the
Lordship will kindly have a look at the judgment once, and I have to, because it's in these similar circumstances, Lordship, in these exact similar circumstances, something major had happened.
Very nice.
And this was also pointed out to the division bench that time.
Yes, tell me.
Lordship will kindly look at this judgment once.
Yes.
An appeal involves a point
Which
of
page,
principle.
which page, which paragraph?
Actually, first paragraph. Appeal involves a point of principle and the authority available to an executing court. Classically, an executing court cannot keep the decree holder awaiting, and even a mere adjournment of the execution proceedings, insofar it can cause prejudice to the decree holder, has been judicially held to be an appealable order. Now, these are facts that has been indicated. I am not going into it, Lordship. Lordship, page 4 of the judgment. Page 4, first paragraph.
Yes.
However, when the matter appeared next before the executing court on September 11, it was found that the state had not obtained a stay of operation of the arbitral award. The executing court, instead of implementing the award by ensuring payment in terms thereof, was released to the award holder, passed an order of attachment to the sum of such and such, which was to the interest maintained with the Reserve Bank. Again, since it was common knowledge that courts are not burdened with heavy dockets, the executing court was well within extend the time to afford a further opportunity to obtain stay of operation. The executing proceedings were adjourned by a order such and such. Execution case was next taken up on November 13. However, quite inexplicably, the form of attachment or security was changed without any benefit to the award holder and possibly not at the invitation of the award holder. The award holder submits that the executing court could adjourn the execution proceedings into such and such for a reasonable period, but once the executing court noticed after a lapse of reasonable period that there was no impediment to the implementation of the award, which is deemed to be a decree, executing court could not have changed the form of the security and denied immediate payment, which was due to the award holder. A cross objection filed. The state exhorts the executing court was well within its rights to give further chance, particularly in the light of the fact the state had pointed out executing court the substance of the application for stay of proceedings under Section 34 was that a government, the state was exempted to under CPC. The state objection is exceptional, apart from the fact that the ground for seeking a stay of operation of the decree or execution thereof has to be canvassed before the appellate forum and not the executing court. The course of action adopted by the state appears to be unacceptable. It was such a mischief which was sought to be addressed by the 2015 amendment, since lethargic award debtors would take the notorious plea of pendency of matters in courts to their advantage and deny settlement of the rightful dues of the award holders. The fact that the principle embodied in the 2015 amendment qua the implementation of awards has been extended by the Supreme Court in Kochi cricket judgment, which demonstrated that even previous mischief was intended to be addressed by the amendment. It would not do so for a state to imperiously deny the rightful dues of an award holder by the wave of a hand, as the state is subject to the laws of the land and enjoys no better position in a court of law than any other litigant unless the accorded special status by any statutory provision. The executing court in this case was well within its authority, particularly in the light of Kochi cricket judgment, then having been recently delivered to adjourn the execution proceedings by the order dated such and such. The executing court again was eminently justified in granting further extension to putting the state on terms. But even when the executing court put the state on terms, it did not result in a benefit to the award holder. Execution proceedings are meant for the fruits of the decree or order to be enjoyed by the beneficiary thereof. The meaningless change of form of security resulted in no benefit to the award holder and has even invited cross objection. In the absence of an order impugned indicating any exception or special the suspension of a court or a natural disaster, for example, the generosity for not implementing the order could not have been extended beyond the first and second time, notwithstanding the award debtor was being put on terms. This is only limited authority which is available to the executing court in warding of the immediate implementation of a decree or an order which is carried before it and passing an order without citing any special circumstances. For this reason, the impugned order is set aside. State is permitted till the workings to pay a sum of such and such, failing which decree will be entitled to cite. This was when the section 36(2) was pending, Lordship. And the attachment order was also made.
GA दिखाना. GA.
GA was already disposed of. Disposed of. That was only for attachment.
Only for attachment.
Only for attachment was disposed.
For release of the money.
Really, it was also for release, but the Lordship said that since it is release for money is already there, we will take it up in the execution application.
Yes, Mr.
My lord,
Banerjee, what do you want to
we
put
have
in your
to-
reply?
we have to see this case at today's position. I know he has grievances so far as past is concerned. Now, today he himself was present in courtroom number 37 while I mentioned it.
Right.
So he knows that I have taken steps. I mentioned it upon notice. He himself was present. I am told by Banaju.
Yes.
Now, Lordship, the amount is secured and attached.
That's
now,
right.
only thing I am saying, yes, there was a delay on my part. We could not do it at right time. Only thing I am saying, give me a time of 21 days. If I can't do, then Lordship will, of course, pass an order. And then Lordship, if your Lordship kindly see the language of Order 21, Rule 26 of CPC, which is applicable here, even in this judgment, it has been discussed. If your Lordship see, we have to see the reasonableness. When someone is in a situation, because this was arises out of a judgment where the security was this, done was not this, so the money was paid to him. But in my case, it is already attached. He knows that the restoration, as a matter of right, and the restoration was also filed within time. He himself said within 30 days we filed. Then Lordship, maybe it could not be listed. We mentioned it today. So it will automatically come by 3 or 4 days or next week. Can't we wait for a week, Lordship? So moment it has come to us, Lordship.
Learned counsel for the petitioner, award holder states that the amount deposited wide the amount attached wide order dated 2nd April 2026 shall be released in his favor to satisfy the award. Full stop. Learned counsel for the petitioner states that the award holder has been denied the fruits of the award since 2019. He contends that the dispute had arisen between the dispute arose between the parties in terms of the work order dated 2010. Full stop. The arbitral proceedings culminated into a final award dated 19/2/2019. Full stop.
And only one
He
claim
further
was
states that the said award was challenged in a Section 34 petition as miscellaneous arbitration case number 10 of 2019, which came to be dismissed by this court by order dated 33/2022. Full stop. He further states that an appeal was preferred against the said order, being FMAT Arbitration Award 35 of 2022, which was further dismissed by this court which was further dismissed in default by this court by order dated 6/5/2025. Full stop. A restoration application had been filed and is still pending, and the same is still pending. Full stop. Learned counsel for the
I have mentioned also for today, both
learned
parties.
counsel for the petitioner states that he cannot be denied of the fruits of the award for learned counsel for the petitioner states that he has already been denied the fruits of the award for a considerable period of time, and that the same cannot be withheld only on the ground that an appeal is pending before this court. Full stop. He further places reliance on an order passed in execution EC number 745 of 2014, dated 13th December 2018, to buttress his argument that the pendency of an appeal shall not debar the award holder to get the award executed. Full stop. Learned counsel for the respondent states that he had already mentioned the matter for hearing of the restoration application before the concerned court. He himself states that if he fails to get any hearing done before the appellate court where FMAT so and so is pending, he shall execute the award within a period of 3 weeks. Full stop. And will not be raising any further grounds
Lordship,
to
kindly
oppose the execution of the award. I'll release the money.
Lordship,
Too much. 2010, 2019 award, it's too much.
Lordship,
He's entitled to be.
my only thing is, Lordship, since I have no written instruction that we will release, since we are on a state bill, we'll take steps accordingly. Like, if otherwise it will come on us, so that we said.
Learned Kasper, the respondent,
Lordship
and is granted only 2 weeks' time to get the matter heard before the appellate court, so that the award holder is not denied of his rights which have accrued in terms of the award dated so and so.
True, Lordship.
Full stop. Let this matter be listed after 3 weeks for necessary orders.
Lordship, I'm deeply obliged, my Lord. Lordship has deleted that line.
I have
Yes, kindly delete that.
Then where where I've given this direction on him. ये जो last लिखा है वो add कर देना बस, ठीक है. Don't put anything on him. Whatever.
I'm deeply obliged. I'm deeply obliged.
We'll get this.
This person is running from similar
We'll get it
situation
executed
happened.
3 weeks. Money will be released next time.
Number 11.
My Lord, this is my application for enforcement of a foreign award. My Lord, the parties are
Please, Your Lordship. My Lord, I am appearing through VC, my Lord.
parties are under settlement. I'm praying that the matter could be adjourned for 2 weeks, my Lord.
Yes, my Lord. I am agreeable to it. Parties are discussing, my Lord. Some discussions have happened. We have made some progress.
Learned Counsel for the parties state that they are settlement talks are underway. They pray for an adjournment. Let this matter be adjourned. Yes, Mr. Kumar, for how long?
My Lord, last week of August, my Lord, we have agreed.
My Lord, 6th of August, my Lord. I'm praying for 6th of August. Then we'll see if there's
No, the agreement, my instructions are the parties have agreed that they will finish it by mid of the August, my Lord. So any day after that, my Lord.
20th August?
My Lord, can it be 13th of August, my Lord?
No, mid of August. Your
No,
representative.
my Lord, if there's any update by
London.
then, no, if there's any update at all, my Lord.
You know, settlement takes time.
Yeah, my Lord, and their representative is in London only. So,
20th August.
deeply obliged.
Yes.
Number 12.
Hello, I'm seeking for a short Passover. I'm being led by Mr. Kumarjit Banerjee. I'm just seeking a short Passover. He's on legs before court 38, Your Lordship.
There's some urgency in the matter.
Your Lordship,
I
a
can
short
wait.
Passover.
That's not a problem. Yeah.
He's our
Possible.
Your
Well,
Lordship, a
kindly
short
not
Passover.
adjourn it because I'll just indicate.
Keep it next Thursday.
Well, Lordship will kindly indicate. See, my Lord, this is my application.
I know your application.
I'm just seeking for a short Passover. He's currently on legs.
Next time. They don't give it, warrant of arrest, I'll issue.
No, let there be one deduction. They have not filed the affidavit as a still date.
Your Lordship, Kumarji, my senior will be arguing the matter today. Your
25.
Lordship, I'm just seeking for a short Passover. Your
I was
Lordship.
only seeking next
May
week. Let them
kindly-
file the affidavit of assets.
They have
Lordship,
already
will-
orally mentioned it. Let's not put it on record. Next week. Keep it a little early.
He's coming. Well, he's coming, my Lord.
He's here.
He's coming. He's dedicated, my Lord. But may just move. I'll just take
Your Lordship,
2 minutes to
kindly
move it, my Lord. By the
Take
time
it after item 13, Your Lordship. He'll just come in a few minutes, Your Lordship.
Next week, Mr.
Next Thursday.
Who's your senior? Who's your senior,
Your
madam?
Lordship, Kumarjit Banerjee.
He's not here. I can't say. Next Thursday.
May I please, Manoj? But today I'm handicapped because of my absence of my junior, my lord. Notice on the last occasion was an order of attachment of a bank account of my client, which was given in an affidavit of assets. My lord, my primary objection towards the passing of the order was my lord, that this court in this execution application does not have the territorial jurisdiction, because all the assets, including the judgment award debtor, lives outside the original side jurisdiction of the owner. Now,
Show me
your
the award.
lordship sees,
Show me the award.
yes, your lordship will see the award is, insofar as section 36 is concerned, then application is pending for your lordship, which has been there. And my lord, the award is at page at 30.
Ma'am, in 36, in my application, it's at page 1. If my lords, I have opened 36 application on the maintainability one.
EC.
Huh?
Have the EC.
Yeah.
The award is page 32.
Yes.
So, my lord, it is outside the jurisdiction of the, because your lordship sees the original side jurisdiction ends on this side of the AHC post road, and the petitioner lives on the other side of the Eastern Bypass, which is territorially outside the jurisdiction of the original side court. The bank accounts are all in the town of Siliguri and North Bengal, outside the original side jurisdiction. So if my learned friend has got agreements, certainly he can do, but he has to file application, execution application in the appropriate courts. Section 36 will certainly lie before this court, but execution application cannot lie before this court.
Yes.
Even assuming for argument's sake that he goes by the part of cause of action, that part of the award debtor is still within outside the original side jurisdiction of this court, he has to go to Alipur court. For canvassing his reliefs.
Yes.
Yes, Milord. Milord, before coming on to the maintainability in itself, Milord, there are 2 points. Award has been passed in this jurisdiction and it's an August 2024 awards. They've already filed their 36-2 application for stay, but they are not pressing that for the simple reason they'll have to deposit the money. So what they have taken an alternative route to file a maintainability. Even this maintainability application itself is not maintainable for number 1. Now, Milord, the law has been quite a while, Milord. It has been settled right from associate contractor, which focused on section 42, but that has been technically gone by way of the amendment, which it came in 36.
Yes.
Now, what Sundaram Finance, which has been the main judgment which appears to have settled today, what's the position? Now, Sundaram Finance, my lords, at the first instance, it has not curtailed the scope of the execution. In fact, it has amplified it and it has given a wider scope to say that you may not have to take a longer route, but you have to you can take a shorter route and go to the concerned court, any court in the country. But it not have to go to that particular court where the award has been passed. Now, from Sundaram Finance only, I'll show that this application is maintainable. And my lord, now one more thing, my lord, the properties are situated within the state. The judgments of Sundaram Finance are all which are outside the state. Execution was in Madhya Pradesh and that property was in Tamil Nadu.
Now, when my lords are exercising a jurisdiction within the state, which may not have a original jurisdiction, but my lords have a supervisory jurisdiction upon the concerned court, where my lords can issue precept under section 46 for an attachment of the property, where Sundaram Finance also says so. Now, my lords, I'll just show from Sundaram Finance few of the paragraphs where it will say that under say that even a longer route, it does not debar a longer route. If my lords may see 625, I'll start what has been the issue over here. The issue over here at 625 is, I'll read.
Do you have any bank account, any property within the territory?
Within the city of Kolkata, I have not been aware, and in their affidavit of asset, they have not said so that it is. Now, what they
should be aware of your
the bank account which we have received the money, it has been the which we have shown, and they have come with their affidavit. In fact, one of the asset which according to us, they have not disclosed it. We have found it that they have filed some writ petition that they have some asset in Siliguri, but they have said that they don't have that asset. But this judgment, I'll just, if will give me 5 minutes, I'll show that my execution is maintained.
This is not, what kind of practices? You're a senior advocate, right?
No, but only one thing.
You're a senior advocate.
I am.
You're a senior advocate. You made your submissions. I'll hear you.
Yes,
Mr. Kundu, I will not hear you. What kind of practice is this? This is what you're going to teach the bar.
No, this is not the question. The question is not.
Let him make his submissions.
Pardon.
Am I denying you the right to speak?
I'm buying down your lordships.
Yes.
Yes, Malaj. Insofar as Malaj, it is, we are not disputing anything that it is not within the city limits of Kolkata. They have filed an affidavit of asset where they're showing that bank accounts in Siliguri and Darjeeling. We tried to find out, but we could not find out any bank account or any property within the Kolkata. But in my humble
How is this maintainable, sir?
Malaj, that's what I'm showing it from Sundaram Finance. I'll show.
Law has transgressed much beyond.
Even after that, the larger bench in that judgment, where it has said that even that section,
Not maintainable.
Malaj,
Let him file his reply.
Malaj, allow me to at least submit it. I'll take 2 minutes. I'll just show 2-3 points, and then Malaj may. I'll just show it, Malaj. If Malaj may see what it says, the issue is whether an award under Malaj, 625, the issue first I'll show it, and then I'll straight away take it to the findings, Malaj. Whether in 625, Malaj?
Yes.
The first paragraph, Placitum B. The divergence of legal opinion of different high courts on the question as to whether an award under arbitration so and so is required to be first filed in the court having jurisdiction over arbitration proceeding for execution, and then to obtain transfer of a decree, or whether the award can be straight away filed and executed. So that's the proposition, that what it says, that you can take a shorter route, you may not have to take a longer route. But then my lords may see at para 9, which is at page 630. Page 630, my lords, are there? Para 9. One of the relevant provisions, the effect of which has not really been discussed in any of the judgments referred to aforesaid, is section 46 of the code, which designs precepts as under. Upon the application of the decree holder, the court which passed the decree may, whenever it thinks fit, issue a precept to any other court which would be competent to execute such decree to attach any property belonging to the judgment debtor and specified in the precept. The court to which a precept is sent shall proceed to attach the property in a manner prescribed in regard to the attachment of property in execution of a decree. Well, I'm not going on section 37 to 39, where my lords have seen that when a decree award is being, what it has been said, is akin to a decree over here. Though I'm not saying that there is a deeming fiction that the tribunal will be as a court. But that is the reason what they said, because there is not a deeming fiction for a tribunal to be a court, it has extended the jurisdiction to wherever the properties are situated. But it has not precluded my lord's jurisdiction under 37 to 39 and 46 also, that if someone has filed an execution to the court where the award has been passed, that court, in fact, in our case, the properties are within the state, the concerned court, my lords have jurisdiction, supervisory jurisdiction also over the concerned court, which can attach the property. So it is not that my lords are at all denuded with the jurisdiction, nor cannot attach the property to meet the ends of justice. For that, my lords may also say under 151, my lords have the inherent powers as well to do so. And if my lords may see even the conclusion of it, now my lords may see para 19, where it has relied upon Madras High Court judgment and said and affirmed it to say that the decree, even if it is been filed before the court, that is not cannot be held that it is not maintainable. It has simply said that execution can be filed anywhere in the country where a decree can be executed. That's the limited submission, my lords, I want to make it, and I leave it to my lords.
You want to withdraw and file in or you want to continue with it?
My lords can transfer it to a concerned court also, my lords, under 39.
Which concern?
My lords,
According to you, this is the concern.
my lords, according to me, this is the court. Now, if
You file your reply, we'll have a intellectual debate on it. Take down.
My lords, then
enjoy the.
My lords, the difficulty is this, that I am
suffer because of this. Nothing else.
My lords, then at least I would request, if my lord, I'll take instructions and then accordingly, if my lords may keep it on next week, I'll take instructions and I'll
back next week. I have no issues. I'll issue necessary directions for affidavits. This will be pending for 2 years, and then you will realize that this is not the right court, and your client will suffer. Anyway,
my lords,
The order of attachment passed by lordships.
we will see that, Mr. Kundu.
Very well. I'll leave it to lordships. I'll leave it to lordships.
Thursday.
Well, the matter-
Grateful.
Next.
Grateful, my lord.
I'll list the 36-2 also.
Yes.
List the 36-2 along with this.
Yes. 36.
At least they'll deposit the money.
Yes, my lords.
Otherwise, I'll dismiss 36-2.
Yes, my lords. They are not pressing their 30.
Secure you here. File
But-
your execution somewhere else.
My lords,
List the 36-2 along with this.
yes.
Give the details of 36-2.
Yeah, यहाँ पे AP 116.
My lord, I am for the award holder. Mr.
AP
Tapus Dottu is
116.
appearing online. He's reading.
Yeah.
Lord, I am Harshvardhan.
Affidavit of execution. It's dinner time and we have already served dinner time.
You're filing affidavit of assets.
One thing you have to
Take down.
okay, no. There will be mutual agreement between the award and the arbitrator. It's a clear evidence of that.
What is there? Sorry.
Unilateral agreement between the award holder and arbitrator.
It's a unilateral award.
My lord, my senior is appearing online.
Yes.
My lord, there is a clause in the agreement that both parties agree to a particular person to be appointed as an arbitrator.
So where is the 12.5 disclosure or the consent under 12.5 that he has agreed for it? Show me the.
Yes, in the agreement is specifically mentioned. Agreement.
Sir, can you show me the clause?
All things party ownership.
They didn't appear. They didn't appear despite service. Kindly come to. I am just referring to the.
Yes, show me the agreement. If it's a unilateral appointment without 12-5 consent, this goes.
Lord, agreement, I want to file by supplementary affidavit because I have already enclosed the award.
Why don't you move an application?
No.
Why don't you move an application that this award is not maintainable? We'll set it aside and put everything, the consent and everything.
Yes, yes.
The 164 move an application, sir. Affidavit of asset filed by the award debtor is taken on record. Move an application. When? How much time will you take to do all that? List after 3 weeks.
Hey. 15 blood I appear for the award holder. I'm being led by Mr. Ghosh. He is online.
I'm sorry, my lord, I got caught up today. I couldn't attend. This is my learned friend's application under section 47, challenging our execution petition. Mr. Shah is there.
Yes.
By 47, the question was whether it is maintainable. I just remind your lordship.
Readings are complete.
I'm sorry.
Readings are complete.
Yes.
Yes.
Well, today, my lord, we are addressing your lordship only on the maintainability. If your lordship holds that the application is maintainable, of course, I'll address your lordship on merits. My learned friend has taken the point of maintainability. Well, I have, my lord, participated in arbitration. I have suffered an award. My lord, I have filed an application under section 34. That application is before the Jabalpur court. Because that is, my lord, although the venue of arbitration was Kolkata, that is the seat of arbitration. My lord, arbitration is at 34, my lord, there. My lord, it's, my lord, pending. My lord, one of the issues in the 34 application is as to whether, my lord, the reference could be continued by the tribunal at all in view of a jurisdictional bar that we had raised. Now, my lord, so far as that question is concerned, although that is also the subject matter of 34, my lord, because I have to take all points of challenge in 34, that is also one of the points of challenge. My lord, the next question is, my lord, whether I can independently resist an execution on the ground that, my lord, the award is not executable because, my lord, it is a nullity. Why nullity? Because it suffers from a jurisdictional bar. There was no jurisdiction in the tribunal to entertain the claim that was filed. That is my lord, my contention. Now, my lord, my learned friends have raised a question, my lord, of course, without relying on any judgments at the moment, saying that since you could have raised this point and you have raised this point amongst all the other points in your section 34 application, you cannot maintain an independent section 47 application on that ground. Well, that is the question that I have to answer to your lordship. Well, at this point, I don't think is any longer res integra. Well, for that, my lord, may I straight away, my lord, request your lordship to look at, well, a very recent judgment of the Supreme Court in the matter of electrosteel.
I've seen that. There's only one clause which talks about 47 there. It's a very restrictive.
Well, electrosteel, my lord, ultimately electrosteel says that it is, my lord, you can agitate it separately.
But on a very limited point.
Well, kindly see that, my lord. I'll try to, my lord, assist your lordship on that. My lord, paragraph 60, my lord, 3 onwards.
Vitiated by fraud or... Yes.
Well, at 63, the decree holder, that is the respondent, filed an execution petition before the executing court for execution of the award dated such and such. In the said execution proceedings being commercial execution case number such and such, the appellant had filed an application for declaring the award as a nullity and hence non-executable in view of the resolution plan approved by the NCLT. By the purported order such and such, the executing court noted that the judgment debtor had not preferred any appeal against the award dated 6 July 2018. Instead of filing such appeal, the appellant had filed an application dated such and such for dismissing the execution proceedings on the ground that the award passed by the Facilitation Council was illegal and non-est in the eye of law. Since the appellant did not file any application under section 34 of the 96 Act, the executing court dismissed the application of the appellant dated such and such, observing that the appellant was trying to deprive the decree holder of the fruits of the award by unnecessarily delaying the execution. The order came to be challenged by the appellant before the High Court in a proceeding under Article 227. We have already noted the three issues framed by the High Court for consideration. Insofar as the first issue is concerned, the High Court is of the view that an award can be challenged in a proceeding under Section 47 CPC on the very limited ground of the award being a nullity or void ab initio or suffering from inherent lack of jurisdiction. However, the High Court opined that if an aggrieved party does not challenge an award under Section 34 of the 96 Act, it cannot be permitted to object to its execution by alleging it to be a nullity, though such plea of nullity can be entertained if it is of such grave nature that it is not even capable of being waived by one or the other party. Therefore, the High Court concluded that the plea of nullity qua an arbitral award can be raised in a proceeding under Section 47 CPC, but such a challenge would lie within a narrow compass. Insofar as the second issue is concerned, the High Court rejected the contention of the appellant that since the award suffered from patent or inherent lack of jurisdiction, the objection to the award can be taken at a stage of execution without challenging the award under Section 34 of the 96 Act. While rejecting the said contention, the High Court held that the arbitral proceedings culminating in the award cannot be said to be suffering from inherent lack of jurisdiction. Then please see paragraph 67 onwards. The High Court is correct in answering the first issue that a plea of nullity qua an arbitral award can be raised in a proceeding under Section 47 CPC, but such a challenge would lie within a very narrow compass. Section 36 of the 1996 Act deals with enforcement of arbitral awards. Subsection 1 says that where the time for making an application to set aside an arbitral award under Section 34 has expired, then subject to the provisions of subsection 2, such an award shall be enforced in accordance with the provisions of CPC in the same manner as if it were a decree of court. As per subsection 2, where an application to set aside an arbitral award has been filed under Section 34, the filing of such application shall not by itself render an award unenforceable unless an order of stay is granted by court. Therefore, in terms of Section 36 of the 96 Act, an award can be enforced in accordance with the provisions of CPC in the same manner as if it were a decree of court. Then, this is the most important paragraph. Section 47 CPC deals with questions to be determined by the court executing decree. As per subsection 1, all questions arising between the parties to the suit in which the decree was passed and relating to the execution, discharge, or satisfaction of the decree shall be determined by the court executing the decree and not by a separate suit. Execution of decrees and orders is provided for in Order 21 of the CPC. The law is well settled that at the stage of execution, an objection as to executability of the decree can be raised, but such objection is limited to the ground of jurisdictional infirmity or voidness. The law laid down by this court in Vasudev Thanji Bhai is that only a decree which is a nullity can be the subject matter of objection under Section 47 CPC, and not one which is erroneous either in law or on facts. Therefore, said proposition of law continues to hold the field. Objection to execution of an award under Section 47 is not dependent or contingent, not dependent or contingent upon filing of a petition under Section 34 of the Act of 1996. The High Court was not justified in taking the view that since the appellant had not filed an application under Section 34, therefore it was precluded from filing an application before the executing court. And then please see, my lord, paragraph 72.
Last paragraph.
Last, yes, my lordship has seen it. My lord, that is the basis on which I say that, my lord, if I am, my lord, assailing the award on the point of, my lord, voidness, on the point of nullity, then I can, my lord, even assail it, my lord, before the executing court. My lord, my rights are, my lord, twofold. My lord, normally your lordship is aware that, my lord, I would have to secure the entire decree, my lord, before I can resist the execution. But, my lord, today, if I can raise a point that, my lord, the award is inexecutable because it is void, it's a nullity. My lord, then, my lord, I can come by way of Section 47, and, my lord, even without securing the award, let us say I have not filed the 36th, I have not secured, I can, my lord, raise that issue before your lordship. My lord, that is, my lord, the short question. My lord, there are several other judgments, my lord, which touch upon it, but electro steel is the most direct judgment on the point. But if my learned friend answers this question, I shall, my lord, be happy to respond. Mr. Ghosh, I don't know.
What is your ground on in 47? It's an.
I'll tell you, lordship. My lord, there was a consortium. The consortium had participated in a bid and was awarded a contract, my lord, for, my lord, preparing underground mines for the Hindustan Copper Limited. My lord, the consortium was a 5-member consortium. Four-member consortium. Well, so far as the consortium is concerned, the lead member of the consortium went into liquidation before the arbitration started. The other members of, my lord, the consortium did not participate in the, my lord, contract at all. And my lord, in fact, the consortium fell apart. One of the, my lord, members of the consortium had itself been sent into liquidation. Now, my lord, section 19, subsection 2 of the arbitration of the Partnership Act, my lord, provides that, my lord, today there is no implied authority in a particular, my lord, member of a partnership or a consortium. Our consortiums have been held to be joint ventures, my lord, to independently, my lord, start proceedings in arbitration. My lord, we said that, my lord, the lead member which had gone into liquidation, my lord, through an authorization made by the liquidator, purported to file the statement of claim. We said that there is no authority of the other, my lord, consortium members on the lead member to file the statement of claim. My lord, no such authority could be demonstrated. My lord, this point was taken as a point under section 16(2). My lord, point was, my lord, ultimately, I shall show you, lordship, my lord, perhaps a little unfortunately, it was my lord, dealt with, my lord, in a very peculiar fashion. My lord, the learned arbitrators took it upon, my lord, it was a matter of ego, my lord. I say that I am right, how can you say I am wrong? But, my lord, I shall not go into that question. My lord, it was not a partnership of will, one partnership gone into liquidation, who, my lord, files the statement of claim. One partner, my lord, has gone into liquidation long back. Other partners never come forward to authorize this, my lord, particular, my lord, company in liquidation, my lord, gone. So, my lord, the partnership itself is gone, dissolved, consortium ceases to exist. And, my lord, that, my lord, was allowed, that one single member was allowed to file the statement of claim, which in law cannot be done. My lord, that is clearly, my lord, the language of section 19 of the Partnership Act. My lord, we had placed that, and the claimant is a consortium. It can sue only as a consortium, not independently. My lord, there are many other points, but, my lord, since I have, my lord, confined before your lordship only to a question of nullity, that is the point I'll, my lord, try to raise and establish. If, my lord, your lordship holds that my application under 47 is maintainable, then I shall make it good.
There's a very narrow compass, you know, you can't really
only nullity, that is all.
Approach upon the 34.
I completely bow down, my lord. My lord, cannot, my lord, join issue on that at all. But if it's only on the question of nullity, and, my lord, on the award being non-est.
Electrosteel, the only reason why it has been set aside or why the court had allowed it, only to the extent because there was a moratorium. There was
No, I'm not on the moratorium.
No, I'm saying that.
Yeah, in electricity.
In electricity. That is the reason why there was a scope for 47.
Yes, my lord, that is true. But, my lord, there are a couple of other judgments, my lord, MMTC and others, but, my lord, those are not so directly on the issue.
Even I have touched upon 47 in one of my my judgments.
Yes. I'll try to look that up. I'll try to look that up. But, my lord, this is what, my lord, essentially is, my lord, the conspectus of, my lord, what we are trying to urge before your lordship. I am, my lord, only on the question of nullity. I shall not encroach on any other parcel of the award at all.
Anyway, yes.
Yes.
Yeah.
Mr. My lord, may I come back next week with the judgments? I'm really sorry. It's my mistake. We have the judgments, but it's not with me right now.
May I only request that Mr. Ghosh makes available the, my lord, citations of the judgments?
Yes, it's better, Mr. Ghosh.
I can then
we
try
can
to
finish off this, you know,
We'll
because
yes,
this point, if
we shall
he
give them.
gives it to me.
but at least share the.
Yeah, we'll give him. We'll give it.
At the request of the learned heard, Mr. Learned Senior Counsel, Mr. Saha, let this matter be listed for further hearing on
next week.
Next week.
Oh, next week. Next week. Grateful.
Grateful. I'm sorry.
What happened to the SLP?
Award holder on the last occasion.
What happened to the SLP?
SLP has been dismissed. Lordship is remembering. Now SLP has dismissed. May I hand up a copy of the order?
Then what is left?
But I just learned about the dismissal of the SLP today, my lord. My lord.
Then nothing is left.
Whereas, my lord, lot of remedies
I'll
have
be
already
referring
been
to the
exhausted.
prayer B in my tabular statement, which is the release of the amount which is lying attached with the Reserve Bank of India.
My lord, my lord, I've learnt of this, my lord. My lord, I will have to, my lord, take instructions on how they, my lord, have to go about it, my lord.
You're the state.
My lord.
What are you seeking now?
Lordship, prayer B, Lordship will kindly see order dated 18th of December 2025,
the amount that was lying to the credit of the state was directed to be
Come back
attached.
with the instruction so that we can come
we
back with the money.
Lordship, the money is lying attached.
No, it is
I'll-
Only that, Lordship, now it is Lordship's direction upon Reserve Bank of India to release the money in my favor. Lordship, I do not think the state,
my lord, made be my lord's kind pleasure.
unless they want to tender the amount entirely in court.
No, my
with
lord,
interest.
we'll have to find out the modalities and we'll have to get it done, my lord. My lord, a fortnight's time, my lord.
All right, let's after 2 weeks.
Lordship, in 1 week's time. Lordship, I have been waiting.
We'll finish it off.
Lordship, my
Nothing
learned
is-
friend's submission will be recorded, Lordship.
Learned counsel for the respondent state. ऐसे ये एक मिनट दिखाना वो order. Learned counsel for the award holder has handed over a copy of the
Mr. Sen is leading me.
order passed by the Honorable Supreme Court in SLP number 12468 of 2026. SLP Special Deputy Civil Diary number 7. While order dated 18/5/2026, the Honorable Supreme Court had refused to interfere with the impugned judgment passed by the Honorable High Court. Accordingly, the special leave petition has been dismissed. In view of the same, learned counsel for the award holder presses for execution of the award. Full stop. Learned counsel for the state states that he is not aware of the order passed by the Honorable Supreme Court. He seeks and is granted 2 weeks time, 1 week time to take instruction. List after 2 weeks.
Instructions to make the payment.
Instruction to make the payment.
Instruction to comply with the award dated. What is the date of the award?
18th of
19th of May 2018.
19th of May 2018. Yes.
17, my lord, my execution of an award, not unilateral, appointed by order of court. My lord had by an order dated 14th May asked me to serve, my lord. 14th May 2026.
Lord, I'm for the judgment letter. My lord, my
Am I-
friend would kindly give me a copy of the execution application and kindly gives me some time. We'll come back
Here
with the
and now I
affidavit.
shall give.
We'll come kindly give some time. We'll come back with the affidavit.
Award debtor seeks and is granted 2 weeks time to file his affidavit of assets.
May my affidavit of service.
Affidavit of first line again.
That's
Affidavit of service taken on record. Learned counsel for the award debtor seeks and is granted affidavit of assets within a period of 2 weeks. List after 3 weeks.
I shall serve here and now. Published.
Lordship, this is my execution. My lord, I have instructions to withdraw since it is an unilateral appointment.
Learned counsel for the petitioner seeks to withdraw the present execution proceeding with liberty to file appropriate proceedings in accordance with law. Yes.
I'm for the award debtor, my lord.
I'm for the award holder. My lord, directed to file the stamped copy of the original award with supplementary affidavit. I am submitting before this honorable.
My lord, I am not favor with the
Mr.
copy.
Mandal, Amrita Mandal, he is online.
But I am not favored with the copy of the supplementary.
Already served to learned Mr. Siddharth Mukherjee. Earlier, my lord, learned advocate appeared.
Yes, I am led
for
by
this
Mr. Siddharth Banerjee, my lord.
Yes, Siddharth Mukherjee. I'm told that.
So maybe his office has been served.
Yes, my lord.
His office might have been served.
No, in court, my lord. One Xerox copy was served to. Yes.
Xerox.
Where is
At that point of time, my
where is
lord, he is appearing on.
Because their supplementary copy we have served today in honorable court before the honorable court, but the Xerox copy served to the my learned friend earlier. I will serve again if my learned friend asks for that.
It's a big problem. Where is he? Where is he?
My lord, Mr. Banerjee is appearing before the courtroom number 16, my lord.
Not today. We'll have it next week. ये लिख लो. Supplementary affidavit filed by the award holders taken on record. List after 2 weeks.
I'm sure.
I appear for the petitioner, my lord.
Yes, Mr. Chaudhary.
Due to some medical emergency, I have to leave the court, my lord. Kindly make it not today, my lord.
I'm sure Mr. Chaudhary will not approve. Not today, then we'll make it not today. Next week?
Next week.
Very well.
Yes, Mr. Lord.
No, I'm for the judgment. My lord, directed to file the affidavit, my lord, I'm filing. But my lord, this is not the 2-1E court. The first objection is this is not the 2-1E court, my lord. Petitioner is outside, respondent is also outside. And
Yes, sir.
initially it
What is
started.
here in the execution proceedings?
Initially the matter started at Rajarhat. They filed a section 9 at Rajarhat. Then this court appointed an arbitrator. But this court appointing an arbitrator doesn't give jurisdiction to this court.
Well, may I just consider that and come back? My affidavit of service may be kept on record because there was a direction on the last day.
Affidavit of service taken on record. What have you filed, Mr. Lawyer?
We have filed the affidavit of assets.
Affidavit of asset filed by the award debtor is also taken on record. Learned counsel for the award debtor states that the present execution petition is not maintainable since this court is not the 2-1E court in terms of the Arbitration Conservation Act 1996. Learned counsel for the award holder speaks and is granted. Time to take instruction. List after. When do you want? Next week?
2 weeks, my lord.
2 weeks after 2 weeks.
HON'BLE.
Name.
Lordship, I'm for the award holder, Lordship. On the last occasion, my lord, they were directed to file a fresh affidavit of asset, my lord.
We are, my lord, filing the same, my lord. We could not have found any difficulty in this.
My lord, the
Let them
form
process
is there, my lord. The form is there.
Form is there with the act.
Form, I have checked, my lord. There is some
16A form, my lord.
things which are not required that can be stacked off.
In fact, my lord, they have given bank account, but they have not given the balance.
And pursuant to my lord's direction, the entire amount is secured. We have communicated with them, my lord.
If the amount is secured, my lord, today I'll be seeking orders in terms of prayer A, Lordship. My lord, there is no stay, my lord.
Kindly see. Let them, my lord.
Lordship will kindly grant us the amount.
Our
Prayer A.
section 34 application is pending, my lord.
Maybe the amount has not been secured.
Yes, my lord, kindly see, my lord, we have communicated them. This is to certify that we have a bank account with State Bank of India, Sonarpur branch. We have an amount of such and such. We have maintained account under the name of Indian Institute of Liver.
My lord, they have to maintain that amount, and
yes,
apart from that, they have to.
So, my lord, let them cross-examine, and my lord, we are also taking steps for my lord hearing of this 34 application, my lord.
Lordship, if they have secured that amount, let us give that amount to us.
No, my lord,
My
in
lord,
that
I'll be
event,
praying, my lord, orders in terms of prayer,
my
Lordship.
34 will, my lord, be infructuous, my lord.
Why? You have not asked for any stay.
No, my lord, that stay application is also in process, my lord. We have affirmed it. We will file.
Long back, my lord, 2025, the
File your stay application.
Yes, my lord. Due to, my lord, this online process, this is taking some time.
Right. Affidavit of asset
Yes, my lord.
filed by the.
my lord, still it's defective because they have not disclosed the amount which is there in the bank.
Let me see. They're saying that they are securing you.
Yes, and that communication I have already handed over to my learned senior friend.
My lord, on 15th of January 2026, my lord, an order was passed in terms of the prayer B of the tabular statement, my lord.
Yes.
Order, they have to secure that amount, my lord.
Yes, my lord,
Only
that is
they have
secured, my lord.
stated.
Where have you stated so?
This, my lord, we have communicated them. My lord, this is the original, my lord. My lord has directed us to secure it and communicate them. We have done so, my lord. Kindly hand.
It's not secure. Only they have said that we have this amount
What is
in
the
our
meaning
bank.
of that? We are keeping that amount. That means we are keeping this amount. We are not. We are maintaining this amount as per Lordship's direction. So if any keeping this account means we are secure that amount. Yes, my lord.
Lordship will kindly pass. If they have secured, my lord,
Obviously,
if they have
but
secured,
release the
Mr.
money, sir. You filed your 36.
Grateful, my lord.
Or at this stage, I'll release the money. Affidavit of asset filed by the judgment debtor is taken on record. Place this matter after for examination after 3 weeks.
My lord, any shorter date, my lord, it's a small organization, my lord.
My lord, even we are a, my lord.
What is this? 3 weeks is a long date.
Lordship, I'll leave it upon you, Lordship. I'll leave it upon you.
Grateful.
I'm for the award holder, minute. But pursuant to my lord's direction, minute, we had served upon the parties, minute, once again. Minute, may I have my lord see to file the affidavit of service, minute? Minute, if my lords will use the affidavit of service, minutes will see that all the parties have been email service has been affected, and when we have served upon them the same through post, most of the letters minutes will kindly come to. I have made a tabular statement in my at page 21 of my affidavit of service, minute. All have come back as returned unclaimed, minute. These are all private limited companies. Some of them are left. Some says no such person left. Page 21 to 24 of the affidavit of service, minute. Each of the corporate entities would have been served on the registered address as mentioned in the ROC. And with this, this is the second service that we have effected. The first service also came back as unclaimed and returned. Now, minutes, party number 1, that is Gagan, was the borrower and the other were guarantors. As per the award, which is 30th November 2025, minute, at page 30 of the application, there was an injunction restraining them from transferring and encumbering the sole asset of which they had given me deposit of title deeds. My lords had, by my lords order of 18 December 2025, protected me to that extent, minute. 18 December 2025, minute, we'll see in the meantime, by way of an interim, third paragraph, minute, interim protection, the award debtor is restrained from selling so-and-so till further of the order of the court. Well, this would be in the nature of attachment. Now, if my lords allow the escrow agents who are holding these properties as receiver to sell it by public auction or by private treaty, minute.
Not right now.
But otherwise, it's 102
Madam,
crores.
you have not even served them. Do a publication.
I have done everything to the best of my ability. Because
Is it this court's job to find those people who you can't find?
definitely no, definitely these are all
Then
registered
what are you
companies.
supposed to do?
The reason, may I just for 1 minute? These are all registered companies. They are also they are supposed to maintain the registered office as per the ROC. At the address in the ROC, whatever is mentioned, change address also we've effected service everywhere.
But then
There will only substituted service is what my lord is directing. Then I'll make a substituted service. But with regards to the fact that they are these, I will not be able to get the asset at all. I have possession, I have deposit of title deeds, but not possession. It'll be encumbered every day.
before I serve them, I should sell the property, right?
But I have the second service affected upon it.
Have they been served, madam?
By email, yes, all of them. By email, at the registered address, everything has been served.
The award holder seeks and is still has filed an affidavit of service. The service report indicates that the award debtors that no service could be affected on the award debtors as the packets have returned as unclaimed.
The left and unclaimed are good service.
As left. She prays for a substitute service by way of paper publication. Let the same be done in an English as well as in a leading English daily as well as in a vernacular newspaper within a period of 4 weeks, list after 6 weeks. How much time you want?
With regards to service, I'll do it in 10 days. But they have to come back in 14 days is the minimum time that one has to. We will kindly keep it 3 weeks hence.
4 weeks. Keep
4
it after 4 weeks. Substituted service within a period of 3 weeks, 4 weeks.
It is recorded the endorsement is left and unclaimed. All good.
That's what I recorded.
Okay. Deeply obliged.
Just call out these two matters. एक minute इसको खत्म कर दो. Just you're filing your affidavit of asset.
Is a matter where, my lord, I have filed an affidavit of asset.
No, my lord, he has not. He has filed an affidavit to the effect saying that there are no assets in Calcutta within the jurisdiction.
That's what I was saying. My lord, I have filed an assets. I have said that there is nothing, no asset within the territory of the High Court at Calcutta. My lord, to that, my lord, they had taken an objection that a first an affidavit of detailed affidavit of assets, as is contemplated under the another civil procedure code, has to be filed, and thereafter, my lord. But to that, my lord, I submitted that there are judgments of this honorable court and the Supreme Court, which says, my lord, if prima facie I say by filing an affidavit that there is nothing within the jurisdiction, my lord, they have a right of cross-examining me to that extent. If something arises out of that, then, my lord, a detailed affidavit of assets should follow. But if I'm saying, then the court initially does not have the jurisdiction, my lord. In my respectful submission, my lord, to even ask me to file an affidavit of assets. Those were my. I have got the decisions
that were made on the last occasion, my lord.
We'll keep it next week. We'll see. Next week.
I have got the decisions. I'll give my.
Do you have any information on their assets?
My lord, they have a registered office, but my lord, there is one more thing.
They listed. We'll see next week, but
I'll just
listed
hand
for their
over one piece
examination.
of paper.
Lord, my registered office, everything is in Delhi.
They are making these submissions, my lord. They are taking us for a.
It's only because you're saying that the Vakalatnama has not been filed. You filed a Vakalatnama.
That is there.
This is their identity, my lord. They have not yet entered.
File your Vakalatnamas.
We have it.
File it in the.
And my lord, he's saying
file it in the department.
My registered office, my lord, both our offices are in Delhi.
File in the Vakalatnama.
Yes, my lord. Deeply okay. All
right, now you call that other.
But one line order that we will file our wakalatnama, otherwise there might be a difficulty because the matter is running in the list.
Learned counsel for the awarded.
That is the difficulty. They have affirmed that affidavit saying that there are no assets within the jurisdiction without a wakalatnama. They have no authority to represent the clients at on that date.
He wants to take these points. Fair enough. I will reaffirm it. Say the same thing.
If they come up
How
and
does this help
Yeah,
you?
how
Does
does
it
it help
really
you?
help you?
they're showing the conduct.
You try to file it, they'll take it.
One line that I will file it. Otherwise, there might be a difficulty. Your lordship knows. Otherwise, I'll come back to your lordship if I
Come
see
back.
this. Obliged. File করতে যাও, অসুবিধা হলে লর্ডশিপকে mention।
Examination of judgment.
Call the person.
Item number 129, NISICOM 477 of 2025.
Who's appearing for him?
We are for the applicant. Award holder.
Lawyer?
আপনার lawyer কে আছে?
বাইরে আছে।
He's somewhere here, my. কি নাম?
আমি তো বলতে পারছি না। বাইরে আমার
Who's the lawyer?
Can you point what?
I think she's there.
Okay.
For the judgment letter, my lord.
Give the oath.
My lord, let a copy of the petition be served, my lord.
Wait, madam.
কি নাম আপনার?
সৌভিক দাস।
সৌভিক দাস। বাবার নাম?
লেট তুষারকান্তি দাস।
লেট তুষারকান্তি দাস। আপনার বয়স?
37।
37 years. আপনার বাড়ির ঠিকানা?
পূজালি ওয়ার্ড নম্বর 1
পূজালি ওয়ার্ড নাম্বার 1
দাসপাড়া রোড
দাসপাড়া রোড
24 পাগনা সাউথ
24 PGA সাউথ
700138
700138 আপনি কি করেন?
আমার আগে ব্যবসা ছিল
এখন কি করেন?
এখন কিছু করি
কি করে আনএমপ্লয়েড আপনাকে যেদিকে জজ সাহেব বলবেন সেদিকে আসবেন তো যদি জানো কোয়েশ্চেন কি নাম তো বললো কি স্পেলিং
SOUPIK
SOU আর আপনি যদি আপনাকে ফর্ম আছে সেটা আপনার ফর্মে আপনার কি কি স্থাবর অস্থাবর সম্পত্তি আছে সেটা জমা দেবেন এগুলো যদি না করেন জজ সাহেব আপনার কাছে স্টেপ নেবেন ঠিক আছে
My lord, may I submit something?
Yes.
My lord, I have been briefed for the first time in this matter. My lord, whatever I have come to know from his family members that he was suffering from cerebral attack, my lord, for the last 4 months, and he was not at his residence, my lord. So no copy of the petition has been served upon us. But may I pray for a copy of the petition to be served upon me so that we can file the affidavit of assets?
I'm taking her number, my lord. I'll serve it immediately.
Deeply obliged, my lord.
My lord, the rest of the persons, my lord, was again served in terms of your lordship's order, my lord.
In terms of the warrant of arrest, Mr. The award debtor has been award debtor. His award debtor number.
His award debtor number, my lord. 2.
Award debtor number 2.
Shouvik Das.
Is produced in the court. He has surrendered or produced? Arrested. He has been produced in the court. Warrant of arrest is discharged.
My lord, I am praying for his release, my lord.
The award debtor undertakes to file his affidavit of asset and assures this court that he shall remain present as and when required. Full stop. Learned counsel for the respondent, award debtor, seeks and is granted 3 weeks time to file her affidavit of assets. List after 4 weeks.
My lord, within 3 weeks, my lord.
3 weeks, that's what I've given you.
Oh, sorry, I couldn't hear, my lord.
My lord, award debtor number 3, my lord, has also served, but didn't bother to appear before your lordship.
You are appearing only for award debtor number 2,
Yes,
not
my
3.
lord. No, my lord.
We'll see when they are.
May I serve it again, my lord, upon them?
Serve him again.
Obliged, my lord.
Obliged, my lord.
Call out the other matters now.
And if your lordship, my lord, so directs, my lord, so alternative service can be made, my lord, by virtue of the paper publication.
First you serve him, then we'll see.
My lord. ঠিক আছে, মাত্র যখন বলছেন তখন
Deeply obliged.
Part 25.
Yes, I am praying for withdraw on the ground of judgment.
Learned counsel for the petitioner seeks to withdraw the present petition. The same is dismissed as withdrawn with liberty to file appropriate proceedings in accordance with law.
I'm appealing for the award holder, Lordship. I apologize. I'm appealing online, Lordship.
I don't appreciate this appearing from the car.
I am sorry. I'll
that again.
make my submissions on the next. I'll do next.
My lord, may it come back after a fortnight, my lord.
After a fortnight.
Grateful, my lord.
Lord, I am appealing for the petitioner award holder. Pursuant to direction, they have deposited the amount in the register.
I got the response.
Entire amount they have deposited.
In terms of certificate,
point out, Your Lordship. What they haven't disclosed here, Your Lordship, before they file this petition, we have filed a petition and petition under section 34, and that is true before the appropriate authority. They haven't disclosed it. After receiving service of that, they have filed it. I am not saying that it's supposed to be stayed for that matter. I am saying that they have not disclosed it yet. And today is the hearing. Today is the hearing of the stay petition.
I was there, but that was adjourned as because the High Court has seen the matter.
I have the documents.
he has the right to file his execution petition.
Yes.
Your Lordship.
He has the right to file execution petition.
Your Lordship, that I am saying. He has right, but he cannot suppress that. That's my only submission.
No, we have not suppressed. At the relevant
Because
time, we have not received any summon.
I have all the documents with me to show to Your Lordship. We have secured above 5 crores depositing before this honorable court, Your Lordship. And we are just seeking, let this application.
File your affidavit of asset.
No, instead, Your Lordship, last order that if we cannot make the affidavit of asset, we will secure the award amount by depositing. We have done that, Your Lordship.
All right. Let this matter go out of the list.
Your Lordship.
Time.
Well, only one line. Let this matter be listed after disposal of the section 34 application.
That's what I'm saying.
Yes,
You mention it whenever you have
Your
to.
Lordship.
Yes.
Grateful, Your Lordship.
Learned counsel for the parties submit that section 34 petition is pending. They pray for this matter to be listed. Go out of the list with liberty to mention at an appropriate stage.
Your Lordship. Great.
Hey.
28.
My lord, Mr. Kajal Roy is appearing on behalf of the petitioner. Due to his personal difficulty, he is unable to attend. We are praying for.
Not today.
Yes, my lord. My lord, and debtors were to file their affidavit of assets, my lord. My lord, I am appearing for the first time in this matter, my lord. I'll be humbly requesting a 2 weeks time, my lord, so that I can file my wakalatnama.
Who was appearing earlier?
My lord, no one was. This is the first appearance, your lordship. But I have served them, my affidavit of service. Only after service,
Counsel for
after
the
issuance of
auditor
notice.
seeks and is granted further time of 2 weeks to file his affidavit of assets. Just after 3 weeks.
Grateful. Affidavit of assets. Affidavit of service.
Detail name, line record. Affidavit of service taken on record. Learned उसके बाद.
Grateful.
नाम लो
My lord, my affidavit of service.
Time for the award debtor, my lord. Kindly allow us some time to file a written objection, my lord.
Objection or affidavit of asset?
Affidavit of asset.
Same order.
My lord, only one thing, my lord. My lord, in case they don't file it within 2 weeks, my lord, negative.
My lord,
They don't file it, then they'll issue. He always wants an order beforehand.
My lord, he should be present on the next day, my lord, to examine if he filed his affidavit of assets.
File the affidavit. Don't jump the gun.
A similar order.
You file your affidavit of asset within a period of kitna time there?
2 weeks.
2 weeks.
E1, my lord, is my execution case. Lordship had originally, my lord, directed the department to serve the petition, my lord, with an office report, my lord. It had come back with the instruction that the addressee had left. On the last occasion, my lord, 11th of June, Lordship had directed us to give us new address, my lord, the corrected address. My lord, there's another service that has been affected by the department. They were required to, my lord, file a report before your lordship.
Yeah. There's a new address. Same state.
No, this is a cooperative society. So we had originally taken the address, my lord, from the register of the cooperative society, because it has to be a registered address. It's not a private. No, I understand, my lord. It must be the same instruction, my lord. In that case, my lord, I'll have to make a prayer, my lord, for substituted service, because here, my lord, there cannot be a separate address. It's not a private person. But this is the address which was mentioned in the registrar of cooperative society in their register. May I make that request, my lord, to direct me to make paper publication in that case? I'm not making for any prayer in my tabular statement at this juncture, because without them coming on board, there's no question of an affidavit of service, affidavit of assets being filed. In fact, in the arbitral proceeding also they participated. The cause title of the pleadings also, my lord, bore the same address.
This we have to see whether we can, when there's a direction under 21, rule 21, 22, then substitute service next week. Show me the, let me check.
Well, substitute service, I'll come within the ambit of that. I'll come within the ambit of
See it next week.
Okay.
Next Thursday.
Most grateful. I'll come back.
Left side.
But I appear for the petition owner. This is
But
the
I
evidence
appear
of
for the
service.
continuous lordship.
They have
Complied.
At least in this matter, my lord, there is I have not left any scope, lordship. And my lord, in
I
this
get a
matter,
copy of
yesterday,
this.
after a lapse of my lord several months, yesterday only it has been complied with.
Yesterday night at 10, the order was communicated. Better late than never.
So lordship kindly appreciate
Affidavit of,
our
affidavit of
copy
compliance
maybe.
taken on record.
sure, sure.
Learned counsel for the petitioner states that the order dated 1/7/2025 passed in WPA number
I'll serve a copy.
3535 of 2024 has been complied with. He does not wish to press the present.
The last part,
The same is dismissed as not pressed.
Grateful. The service will be taken. Affidavit of service.
Affidavit of service taken.
Lord, I have served a copy to my lord.
Yes, yes.
Yes, my lord.
I have recorded that.
Grateful, Lords. Deeply.
Grateful, lordship.
My lord, my lord, I am appearing for the petition, my lord. It a real benefit matter. My lord, kindly see the order dated 18 June, my lord. Paragraph 4 of your lordship's order, my lord. No reply has yet been filed, my lord, till now.
Well, in this matter, I am appealing for the municipality, my lord. My lord, item number 2, 3, and 4. My lord, all these three matters were earlier disposed of by lordship on the basis of my submission that PPO has been issued in all three matters, my lord. My lord, unfortunately, for the financial crunch in the municipality, the terminal benefits that could not be given in full, my lord. My lord, since the board is not working right now and administrator has been appointed, my lord, some breathing place may be given, my lord, so that he can take charge and comply with your lordship's order and disburse the terminal benefits to the applicants. Item number 2, 3, and 4, my lord.
Have you made the administrator a party?
Yes, my lord.
Yes, my lord.
And copy of sir, my lord.
Administrator, the person.
Yes, yes.
All right.
And
Yes,
copy
ma'am.
of sir.
Do it in 3 weeks' time. Learned counsel for the.
My lord, a larger time if your lordship kindly so pleases, my lord.
These are
A lar-
pension matters,
My
gratuity
lord,
matters, please.
I understand.
No larger time.
Retired on, my lord,
Just
2012.
can. Yes, filed.
Can
Filed
what?
a can.
Can, yes, my lord. 2012 তে রিটায়ার করেছিলেন।
Reply to the said application. Decision can. Learned counsel for the respondent municipality states that seeks and is granted. States that due to financial crunch, they have not been able to comply with the order dated 2/4/2026 passed in comply with the order dated 15/7/2025 passed in WPA 18494 of 2024. He seeks and is granted time to file his compliance report within a period of 3 weeks. List after 4 weeks. So date there. 14th. 14th there, no? Within 3 weeks. 3 weeks करके 14 दे दो.
Matter will dispose of lots.
Grateful, your lords. Grateful, your lords.
Yes, sir. Let the matter will be recalled. You file a recalling application.
Yes.
You file a recalling.
Yes.
matter
Recalling the order
dispose
dated 2nd
without
April, my lord.
lordship. Matter will dispose and file a recalling application.
Yes.
এটা recall না
Can
হলে
one.
হবে না। Recall তো করাতে হবে।
না, এটা পেন্ডিং নাকি ডিসবার্স করে তো মিটেই গেল।
Recalling না হলে তো order pass হবে না। Without recalling the order pass হবে।
Oh, you were supposed to file your reply, Mr.
Yes,
Basu.
my lord, within 1 week, my lord, I will file it. But since, my lord, the municipality is suffering from financial crunch, my lord, and it is our obligation to pay the retail benefits to our
For
applicant.
the municipality seeks and is granted 1 week time to file his reply, though he further states that they shall comply with the order dated so and so in WPA number so and so. List after 7th है ना? 11 को दे. On 7th ना? हाँ ठीक है.
ওটাও 7th আছে কালকে।
Lordship
7th.
Gratefully, Your Lordship.
Seventh.
Yes.
Next, my lord.
Can. In item 3 also there's a can.
3, 4. 3 and 4.
Same order.
Yes, I'm grateful to Lord.
Part payments have been done, my lord.
That's all right, but you made a wrong statement, Mr. Basu.
Yes.
It's on your statement.
On
I've
the basis
disposed
of
it off.
disposal of the contempt application.
Mr. Basu, I'm not holding you. Next time I'm going to record things against you.
My lord,
You
my lord,
better
it was
comply, Mr. Basu. Better comply with the order. I'm being
My-
lenient. I'm giving you an opportunity.
my lord, my lord. My lord, that was
Don't compel this court to record adverse findings against you.
my
It
lord,
is
my
on
lord.
your statement that I had disposed it off.
Yes, my lord, that was the instruction
Please
on
ensure, Mr. Basu, take it personally and ensure that on
My
the
lord, my lord.
next date, the order is duly complied with. Otherwise, I'll be constrained to pass order against you.
My
And
lord,
this
my
is your personal statement.
My
And
lord,
I
that was the
don't want to
instruction, my lord. And that was my instruction I
Mr.
received.
Basu, I don't want to pass any orders like that.
My lord,
All right.
my lord,
So ensure there's a compliance of the order.
my lord.
2, 3, and 4, my lord.
2, 3, and 4.
I'm grateful to Lord.
Grateful, Your Lordship.
Item number 5.
Item number 5, my lord, I appear for the petition, my lord. There was a direction for filing of the affidavit by the municipality.
Yes.
And my lord, the Bishop Bharati.
The municipality, my lord, after the passing of this order, my lord, the board has dissolved. So, my lord, I am praying, my lord, for some time, my lord, for filing the administrator has come into play.
You have to, Mr. Mukherjee, then you have
My-
to make the administrator a party.
Yes, my lord, as of now, my lord, we have to. And their presence is necessary because of the fact, my lord, that they say, the Bishop Bharati says, my lord, the municipality did not have any authority to issue, my lord, the plan in respect of my client. So, my lord, they are not basically to answer whether not my land falls within their jurisdiction or not.
Correct.
5 and
Learned
6.
counsel for the respondent, Bolpur municipality states that the board has already been dissolved and an administrator has been appointed. Learned counsel for the petitioner seeks and is granted liberty to add the administrator as a necessary party to the present proceeding within a period of 2 weeks. List this matter on the 14th they rakha na? 14th. Let's sit on the 14th. Learned counsel, let them be added a party and then
Well, 5 and 6, may I file my opposition, my lord, for the Bishop Bharati, my lord?
My lord, the reply to, my lord.
affidavit of opposition
reply only.
filed by
Bishop Bharati.
respond number.
Oh.
1. Respond number 1. Vishwa Bharati is taken on record. Reply to the said affidavit in opposition filed by the petitioner is taken on record. Respond number 1 and 2. 1 and 2.
Yes, ma'am. 1 and 2.
1 and 2. Why do you need a copy? 1 and 2. Okay. The other also then same order. In the other also then it will be the same order. They'll be made a party and serve them so that they can file their reply. And this take the reply. Affidavit in opposition filed by the respond number 1 and 2 is taken on record. Reply to the said affidavit in opposition is taken.
I'm grateful.
14th August. 14th August, Mr.
My lord, as your lordship, please. My lord.
Item number 7, my lord.
Item number 7.
7 টা কোনটা?
7 also you have filed your affidavit in opposition.
My it is
নাম্বারটা বল।
7 is my lord, it is Bishop Bharati's petition. I am filing my affidavit in reply, ma'am. I am led by Mr. Mojumdar.
So this was in 5-6.
That was 5, 6, but this is 7.
Okay. 7 में लिखना reply file.
But that is for them, lord, to implead. Bishop Bharati, I mean to say.
Learned counsel for the petitioner उसमें कर देना seeks and is granted liberty to implead the administrator of the Bolpur municipality as a party respondent to the present proceeding. The same shall be done within a period of 2 weeks. उसके बाद कर दो reply to the This is affidavit in opposition. Reply to the affidavit in opposition. Reply to the affidavit in opposition filed by the petitioner is taken on record. Affidavit in opposition of respondent number 7 and 8. ठीक है?
Much obliged.
The rest of the matters Monday.